As a general observation here, I think what's happened is the state, the justice system, the government, has basically got itself caught up in its own propaganda. It's kind of assumed a kind of working class toe rag who has no resources available to him, and who gets stuck in a courtroom with a court-appointed lawyer who says yes my lad, no my lad, and can't really do anything about it, is completely at the mercy of the government, of the justice system. And the justice system obviously has infinite resources available to it, as in your resources, your tax money. If you pay income tax, or you buy fuel, or you buy food, or you buy anything with a VAT on it, you pay the government. It's your money, not their money, and they then use your money to persecute you through the justice system, which is ironic, isn't it? In this case, in terms of lack of resources, that was probably true early on in Tommy's activism, when he didn't have much to rely on. That's now changed substantially with the raising of the money to fund this thing, which is something the state would never have seen coming. And if they'd thought they at some point would be looking down the barrel of the gun of a competent defence team filing an appeal at the law courts in London, they'd have thought through their response to his filming a lot more carefully than they did, and they certainly wouldn't have dragged him off the streets, put him in court and sent him out to Hull prison in 3 hours the way they did, because a lot of things have gone wrong along the way, it turns out, which came out during the trial today. So they've basically got themselves caught up in their own propaganda, and will probably see the whole thing, or potentially at least see the whole thing unravel as a consequence of that. So, going on to what happened in court today, a lot of interesting things came out. We had suspicions about some things, and we didn't know some other things at all. One thing was the nature of the appeal. People thought it was about the sentence, which it kind of is, but what they're actually doing is appealing absolutely everything from the Canterbury trial last year, which generated the suspended sentence, through to the suspended sentence itself, obviously enough, and also the contempt charge from Judge Marson in the Leeds trial a couple of months ago. The grounds for the appeal of the Leeds conviction are that dear Judge Jeffrey didn't actually ensure that Tommy understood the nature of the contempt charge against him. It wasn't explained to him fully, it wasn't made clear what it was he was actually pleading guilty to, and as such, jackass Jeffrey, the McJudge, because surely he got his judge qualification from McDonald's, has actually in effect broken the law. He's broken the rules, and there may be substantial grounds for the whole thing falling apart, potentially, on that basis. The Judge Burnett, said that there needs to be absolute clarity as to the nature of the charge put to the defendant in order for him to defend himself against it. For example, in a slightly bizarre future where somebody is up for a burglary charge, which is actually a murder charge, but he doesn't understand that it's a murder charge, so he decides to plead guilty, thinking he's going to get about a year, 6 months for good behaviour, goes to the judge says, thank you very much for pleading guilty, guillotine for you, my lad. He says, hang on a sec, that's a bit severe. Well, you didn't know what you were pleading guilty to. That's an exaggerated example, but it makes the point that you need to understand the nature of what you're pleading guilty to in order to be able to fairly defend yourself against it. And it wasn't made clear that Tommy understood the nature of the charge against him. In terms of the Canterbury trial, Tommy's defence team have said that there were procedural inaccuracies in the Canterbury trial which the Crown have suggested aren't sufficient to, in effect, call a mistrial, but for which Tommy's team says Jackass Jeffrey should never have had that particular dossier in front of him because of the procedural inaccuracies it contained, and that particular charge be thrown out on that basis, and consequently the adherent suspended sentence. Judge Burnett quoted Jackass Jeffrey, the McJudge, as saying that he made an order, the gagging order he put on the trials. I made an order prohibiting publication of anything relating to these trials, is what Jackass Jeffrey said. And Ian Burnett has said to that gagging order on the Muslim gang rape trials was too broad and vague, and it doesn't comply with the law. It's basically an illegal or a procedurally inappropriate gagging order. A couple of interesting things which we knew nothing whatsoever about also came out over the course of the day. On one occasion, Tommy's legal team had an appointment with Tommy in Hull prison. 2-hour scheduled appointment, and he came down, no problem, all good to go. One small problem, however, he wasn't there because he'd been moved to Onley at that point, and the prison system in their Alzheimer's moment had forgotten to mention the fact that he wasn't actually there anymore. On another occasion, when he actually was at the right expected place, somehow something happened to cause them to not bring Tommy in until about 60% of the time allotted to him had expired, and there was hardly any time for the meeting. Another massive Alzheimer's moment, apparently. Also, as we assumed was the case, Tommy asked for more time to instruct his own solicitor, and it was actually denied to him. We suspected that they'd said, okay, you can either have, it's going to go ahead at this time, you can either have the court-appointed solicitor, our lad, or you can have nobody, but it's going ahead, and if you can't get whoever your solicitor is here in time, you're going to have to be without a solicitor. And the legal team have obviously suggested that this was another procedural inappropriateness on their part. Tommy also, it turns out, offered during the course of the trial, such as it was, to delete his live stream. Just get it off the internet completely. And this wasn't acceptable. You'd think they'd say, well, yeah, I mean, it's not necessarily going to change things, but getting it off the internet in terms of the contempt, the prejudicing the trial, would be a good thing. Not at all. They said categorically, apparently, that he couldn't delete the live stream from the internet. And also, turns out that they knew about it. The police, the judge, knew about Tommy doing his live streaming from when he started doing it, and they didn't pick him up until fully an hour and a quarter into it. They were aware of it, but they just let it go on, which would suggest that they were waiting for him to incriminate himself with something much more damning than reading from newspaper reports and saying random innocuous things to 2 or 3 defendants as they came to court. He never actually did, so they pulled him in after an hour and a quarter and tried to make it stick with what they had. And it was also noted that several times during that hour and a quarter, Tommy said to the police, am I okay here? I'm not on court property. Is there anything I'm doing wrong? I.e., he showed good faith as a reporter, as the defence team put it. They suggested that the treatment Tommy received on the day of the trial was not in keeping with the level of the apparent crime committed. The crime, such as it was prejudicing the Muslim gang rape trials. It wasn't anything. It wasn't murder or anything like. But the treatment he received from the court was as if it was. He was offered limited visits, limited phone calls, privileges which prisoners in his own particular circumstances would normally receive and which were denied to him. He was treated as a far more serious criminal than he actually was. Ezra, during his tweeting about this, suggested, and I was forming the same conclusions as I was reading what he was saying, that Lord Chief Justice Burnett wasn't remotely antagonistic towards Tommy. He seemed to treat him quite favourably. And something interesting he said, if you look at the live stream, which I've got on my channel, the 75-minute live stream, at 6 minutes 38 seconds, Tommy talks briefly about the cost of the Muslim gang rape trials. And Justice Burnett said, in what way does this, talking about the cost, represent contempt of court? So he's moving beyond just saying, okay, it's a procedural crime, what he's doing, and he's actually looking into he started, for the first time, it seems, looking into the rationality of this whole thing. Okay, is it contempt of court? Is, in this case, talking about the cost actually contempt of court? And I haven't seen any suggestion that anyone was actually rationally looking at this whole thing as it was the crime that it's being alleged to be, which is a slightly unusual turn up for the books. The defence also pointed out that Tommy's sentence was inappropriate, it was disproportionately long, and it doesn't reflect any precedents for such so-called crimes, and that there wasn't time during the 3 hours it took to deal with him to actually put this forward as a defence, that he wasn't being treated fairly, that everything was disproportionate. So to summarise all that, at Leeds, Tommy wasn't told exactly by the judge what it was he was guilty of. It wasn't made properly clear to him the nature of the charges, and he wasn't able to properly defend himself or offer a proper defence against it, because they weren't put to him clearly, and the time the whole thing was rushed through in. The judge failed to set out properly the powers of punishment and detention as per criminal procedure rules. Tommy was given insufficient time to reflect and take advice as per the rules, and in particular regarding mitigation, things which could be set out in his favour, mitigation of any problems, any actual problems he might have caused. They also say that summary procedure should not have been used in this case. Summary procedure basically means it was a kangaroo court. It was totally inappropriate the way that he was dealt with. The sentence was imbalanced, i.e. it was completely disproportionate to the nature of the apparent crime committed. The prosecution has, or rather the Crown, has suggested that although there were inaccuracies, procedural inaccuracies in the processing of all this, the spirit of the matter was complied with, and this is basically sufficient. The so-called procedural inaccuracies are not sufficient to invalidate the charge, which the defence obviously thinks is wrong, and that the inaccuracies should basically cause the whole thing to be thrown out. There were apparently procedural inaccuracies, they don't say exactly what, in the original Canterbury trial, and in the Leeds trial, Jackass Jeffrey, the McJudge, didn't actually explain to Tommy the precise nature of the charges. That is the defence's contention, and it's all rather ironic if you think about it. Here it suggests that although there were quite glaring inaccuracies, it would seem, in the processing of all that, it doesn't matter because the substance is more important than the procedural inaccuracies. Although the fact of not having the nature of the charge being properly explained to the defendant is obviously, well, it's procedural, but it's very substantive as well. But that those procedural inaccuracies, as they call them, aren't sufficient to have the whole thing thrown out. which is strange because when